final of the conference, but I think 5 minutes will be okay. They said that you are tired, and my presentation will be, my topic will be about class action in Russia. So that's why I prepared a presentation. First of all, I want to greet the participant and thank the organizer of the third Cyber Forum. I'm very pleased to perform in my alma mater, Argentina State University. It's one of international recognized form of collective defense of the rights and interests of citizens abroad. The problem of protecting collective rights and interests of people is relevant for Russia. Since the global trend of massive violation of the rights of citizens had not bypassed Russian society. Now we see recent examples of massive violation in Russia. Need to say that most of civil cases in Russia are focused on protecting the rights of consumers. As follows from the official statistic of the Supreme Court of Russian Federation, the number of cases from 2016 increases by an average of 10% per year. The introduction of class action mechanism in the field of consumer protection may lead to decrease in the charges on the judicial system. Having originated in the UK, it thrived in the United States and was used extensively to protect the rights of public from financial and industrial corporation and from damage caused by human action to a large group of individuals. Article 46 of Constitution of Russian Federation guarantees everyone judicial protection of rights and freedoms. Historically, Russia had developed several ways to protect violated rights and interests of group of persons. That is, representation, required joinder and protection of rights of other person or general public by the prosecutor, as Dmitry Tumanov said today, state and municipal bodies and non-government organizations. The practice of considering a multitude of separate lawsuits with similar claims against the same defendant proved the complexity and intricacy of available legal tools to protect the interests of these plaintiffs at all stages of the case trial, from filing the case to enforcement of the judgment. Some form of collective redress can be found in almost the member states of European Union. In April of 2018, the European Commission released a comprehensive consumer protection policy package known as the New Deal for Consumers. This package contains a proposal for a directive of representative action, which would introduce an European Union-wide system for consumer collective action. Despite the significant numbers of proposals to replicate the Anglo-Saxon system of private class action, the legislators of European countries did not accept that idea. In Russia, the scope of group litigation tradition follows legislation on environmental protection, consumer rights, protection of security investors, and copyright. However, there were cases in the court practice when even legal actors granted to the right to protect the interests of the other person directly by the law faced obstacles to initiating proceedings. The courts do not take into account the fact that in reality the general public and the public good is determined not by the literal wording of the law, but by its logic and the nature of the legal relations. An exhaustive list can lead to the violation of citizens' or organization rights to access justice through class action lawsuits, due to the violation of financial institutions, a lack of state control, and legal regulation in some areas, and the possibility of violation of collective rights in specific areas of the society not included in the list of cases enumerated in the civil procedure law. Conditions for class action is, you see, first of all, there are quantity requirements for group litigation in Russia. There is different, you see, because of the quantity of plaintiffs. For example, the draft law of Civil Procedure Code would establish the procedure for a group per person with a collective statement of a claim to apply the code. Representation in cases of protection of the rights and legislation interest of a group person. The replacement of the person who has a bill for the protection of the right and legislative interest of a group of persons. There is the next requirements of class action in Russia. We have class action now in two procedure codes, in commercial courts, procedure codes, and in administrative justice code. There is a, yeah. So what about model of class action in Russia? Now I see three main model of class action: opt-in, opt-out, and mix model. Class action are categorized as opt-in or opt-out model according to the rules of group members' involvement in class action. To my mind, in Russia we have mixed model because, like in, for example, in Denmark, legislation of Denmark allows opt-in and opt-out class action to be filled depending on the prices of individual material demands. The amount of which does not exceed 2,000 kroner, about $320, that's up to 2,000 kroner is opt-out model. More than 2,000 kroner opt-in only. What about representatives who can initiate class action in Russia? I've said about prosecutor, state bodies, and non-government organization. It's the main actors. Despite the annual increase of number of non-profit associations in the Russian Federation, whose charter purpose is, in addition to judicial protection of the rights of consumer market, to ensure the quality of protection of consumer collective rights and legitimate interest of citizens, such public associations still require significant development. In the existing procedure codes, there is no procedure for examining the claims of a public association authorized by law to protect other person in the order of group proceedings, in connection with which the requirements of organization are considered by the court in the manner of ordinary lawsuit proceeding. The lack of mechanism of judicial protection by professional plaintiffs of collective rights and public interest, depending on general accepted global practice of involving those whose rights have been violated, creates obstacle to the development of the institution of the public class action, representative class action in Russia. One of the most successful national example of collective rights protection implemented by public organization is the protection of copyright holders and other related rights. This protection is carried out by a non-profit organization, for example, Russian Authors Society, which are accredited by the state as represented by the federal executive body, which take control and supervision function in the field of copyright and related rights. Now you see statistic about NGO sections in Russia. It's not too high, from in other lawsuits. So, needless to say that the potential capacity of the class action is general, and representative class action in particular as a modern procedure form of collective judicial protection is considerable. At the same time, concern grow in the economic community over the extensive use of class action in Russia, because the mechanism for determination by the court of objective criteria for initiating of class action, group certification, and the active role of the court in collective proceeding are still being established, which can give a rise of mass violation of applicants' rights either when applying or at the stage of hearing. The introduction of class action in civil proceeding is also a serious challenge to a system of court of general jurisdiction. The class action is the same with the insolvency, bankruptcy proceedings, cases that are heard by specialized commercial courts, whereas class action in courts of general jurisdiction requires the same level of expertise of federal judges and trusted with the right to try such cases. Now we see some idea to discuss. My idea to discuss. Thank you for attention.